where the Court of Appeal Judge Martha Koome and Pamela Tutui are today facing the Judicial Service Commission as it continues to interview candidates who wish to be Kenya's next Chief Justice. Judge Koome has a total of 26 years experience, both as a legal practitioner and a judge of the High Court and as judge of the Court of Appeal. Lady Justice Koome was appointed judge of the Court of Appeal in January 2012. She has distinguished herself as a defender of human rights, concentrating specifically on gender rights. Let's cross over there at the Supreme Court and listen into how that interview is going on. Where are you going?
Ignore their rights, sit back, be complacent, and wait for the magistrate to go through the motion?
No.
That's your view?
No, that is not my view. My view is that everybody should defend their rights and should claim their rights and should go to court. And if they are not satisfied with the magistrate's court or the High Court, they should progress to the highest court as the law provides.
Let's move to the second point, the second question that I want to address myself to. You had the Wambui case in Nyeri.
Yes.
In the appeal bench.
Yes.
Subsequently, your decision came to the Supreme Court. It was overturned.
Yes.
You then had to consider initially the question of time.
Yes.
Which is set under Article 87.2.
Yes.
At 28 days.
Yes.
Insofar as petitions emanating from the High Court are concerned.
Yes.
I have previously had submissions before this panel of the question of jurisdiction of the Supreme Court under Article 163(4)A and 4B.
Yes.
Do you consider election petitions as touching and concerning the interpretation of the Constitution?
The issue of time was not in the Wambui election petition, was not an issue before our court. It was also not an issue before the High Court. We looked into other issues that were raised in that appeal and found that looking at the overall evidence of the processes that were applied during the voting, you could not tell that who was the winner because of even the small margin of votes. And when we actually looked at the evidence, that small margin disappeared, so we could not tell who was the winner. So the matter came to the Supreme Court, and I think the Supreme Court accepted it under the principle of interpretation of the Constitution that they call the normative derivative of the Constitution, that the rights of the candidate were violated, and admitted that petition and the jurisdiction of the Court of Appeal. The danger in that is that in every election petition, I think the rights of the candidate are affected one way or the other. So the Supreme Court is likely to have an avalanche of election petitions, and they could even go as far as MCAs. Yeah. So the Supreme Court may have to rethink how it is going to recharge that jurisdiction.
Should we sacrifice the rights of those aspiring for political office at the altar of expediency and of convenience of the court? And don't all Kenyans have a right to come to court and agitate for their rights where there's a violation?
Precisely, that is the point, that the Constitution gave the jurisdiction that it gave. But the Supreme Court went further and opened it up because...
No. The Constitution says 163(4)A, in application and interpretation of the Constitution. That's why I asked you. Yes, that's why I asked you whether you consider an election petition as concerning the application and interpretation of the Constitution. That's why I asked you that question.
So far, where we are, that is the position of the law because we are bound by the decisions.
I want your views. I want your views, Judge. Your views.
The Supreme Court. Yes. I think it will reach a point where the Supreme Court will have to clarify what they can accept in the Supreme Court as an interpretation of the constitutional issues in election petitions. That is what I would say, because looking at it, I can see it's going to be a problematic area to handle all the petitions that may turn up in the Supreme Court.
Isn't it a question of framing, on whether the framer of the litigation refers to or applies or seeks an interpretation? Only then would it end in the Supreme Court.
Yes, that is when it will end in the Supreme Court, but in every case, it is the Supreme Court itself to decide whether to admit it or not, like it did in all the petitions that ended up in the Supreme Court. Yeah. The leave was not even sought in the Court of Appeal. It is the Supreme Court itself that examined the matter and admitted the matters.
Yes, Judge, because it is under 163(4)(b,
yes,
where certification of the Court of Appeal is required.
It's required,
yes. Like in the Malcolm Bell case, which I will move to shortly.
Yes.
On the other question that I wanted to ask is, what would, on the question of time, and you've seen the Supreme Court setting aside several decisions of the Court of Appeal, what, in your view, should a court do where an election petition is bad ab initio? Should it sit back and say it was not an issue in the Court of Appeal and therefore we can do nothing about it? And the proceedings were nullity from the beginning. What should a court do? And what do you consider a substantive justice?
Substantive justice is, I wondered why the issue of time was not raised in the High Court.
But what if you can see it, Judge? You are a judge, you are sitting, the election petition is out of time.
Yes.
Do you wait for an advocate to raise it? I understand the adversarial setup is not inquisitorial, but you are there and the time frame is clear to you as daylight. Would you abdicate your responsibility as a judicial officer to do justice because it has not been raised?
I wouldn't. I would actually ask them to address me on the issue of time and give them time even to adjourn and go and prepare to address me on the issue of time that has come to.
Let me move to the Malcolm Bell case, Judge.
Yes.
You had the Malcolm Bell matter against His Excellency President Moi.
Yes.
And held in favor of Malcolm Bell.
Yes.
On the ownership of the Kabarak property.
Yes.
Now, did you consider why didn't you consider adverse possession as a principle that was applicable in favor of His Excellency the President? Having been on the land for all the years.
Yes. That principle was not applicable because...
Why? That's the question.
Yes.
Why wasn't it applicable?
Yes, because Kabarak did not move there. They moved there with the arrangement that they were going to purchase the land through barter trade, that they were going to take that portion of land, and in return, Moi was going to supply them with electricity and water as consideration for the property. He did not do that. And he did not, he stayed in the land, and all the time Mr. Bell or Malcolm were constantly asking, when are we going to receive the consideration? And they would always be promised that it is going to come. Then they could not sue because Moi was in office as the president and protected from civil litigation. So when Moi left office, that is when they were able to file a suit. But the principles of adverse possession, moving in quietly, without any force, those principles were not applicable.
So wasn't it, therefore, an important point that that principle and its applicability ought to have been settled by the Supreme Court once and for all?
They probably needed to, I don't know, but they didn't.
They needed to, but they did not.
You know, as a judge, I'm trained to accept a ruling by a court that has heard a matter and come to a determination, you know, because they are the ones who had the application, they are the ones who interrogated these principles, they are the ones who came to that conclusion. So because I wasn't there, I cannot say they were wrong or they were right.
Yes.
Yes.
Lastly, Judge, I know that my time is up. You previously served as the chair of FIDA.
Yes.
And I think you are an activist.
Yes.
You were an activist prior to appointment to the bench.
Yes.
In matters relating to women and children.
Yes.
What is your philosophy?
My philosophy is always to push for a fair, just, democratic society where every citizen lives in dignity, is protected by the law, is aware of their rights. They can come to court and access justice and claim their rights.
How safe is a litigant, Judge, before you, where you are hearing a matter involving the violation of rights of a woman or of a child, given your philosophy?
Yes. That is the philosophy that runs through our Constitution. The national values of our Constitution is we treat everybody with dignity, non-discrimination. Yes.
The inner judge, wouldn't the inner you sympathize and want to hold in favor of the violated woman and child?
The inner me sees no gender when I'm dealing with litigants before my court. The inner me sees justice, sees equality, sees access to justice. It doesn't have to be a woman. Even a man sometimes is a victim